Good afternoon and welcome everyone to the sixth webinar of our digital dialogue series, which brings together policymakers, academic experts, field practitioners, and survivors in a conversation on the progress and challenges of national efforts to address impunity for sexual violence and conflict. I'm Chloé Marnet-Bassanger, and I lead the UN team of experts on the rule of law and sexual violence, which has the pleasure to co-host these dialogue with our academic partner, including today the European University Institute School of Transnational Governance. Our digital dialogue series have so far covered progresses made towards accountability for sexual violence in conflict, with discussions around the recognition of CRSV as a crime at the normative and political level, and a survey of accountability initiative, notably through performing deep dive into specific prosecution efforts in Latin America, Central African Republic, terrorism and trafficking context. Today, we move beyond the criminal prosecutions, and our discussion will focus on an often neglected part of justice processes for survivors or victims of conflict-related sexual violence, the provision of reparations. In the word of the Undersecretary General Pramila Patten, reparations are often what survivors want the most, but receive least. The team of experts was mandated by the Security Council to consider the full range of justice measures available to address conflict-related sexual violence. Criminal accountability is at the core of our work, but beyond, we incorporate the use of reparations for victims or survivors of conflict-related sexual violence in all of our initiatives. Just recently, Iraq enacted the Yazidi Survivor Law, which our team, amongst others, worked on. The bill provides assistance and reparations for survivors of victims of conflict-related sexual violence from members of the Yazidi, Turkmen, Shia, Christian, and Shabak communities. Today, we explore the following important questions. Have we moved the needle on the provision of reparations for survivors of conflict-related sexual violence? What legal frameworks can we use when we're pursuing strategies for CRSV? And what are the remaining main challenges and avenues that are open to us when working on these issues? We have with us 5 leading practitioners and experts whose daily work seeks to best address the delivery of reparations to survivors and victims of conflict-related sexual violence. And to lead us through this dialogue, I'm truly delighted to introduce to you Professor Ruth Rubio Marin, a professor of the Universidad de Sevilla in Spain, and the European University Institute's School of Transnational Governance, the latter one of the hosts of the team's digital dialogue series. Ruth is one of the world's leading academic and practitioner on the issue of both gender and reparations, whose work, the Gender Reparations, has guided practitioner in this field for well over a decade. I will now turn this dialogue over to Ruth. Thank you so much, Ruth, for moderating today.
Thank you, Chloe, and to the team of experts, and thank you to the organizers. Now, before we start, I would like to first inform the audience that they have the possibility to ask questions to the panelists in the Zoom chat. We will answer some of those questions during the Q&A in this webinar. And the chat is unfortunately not accessible to the viewers on YouTube Live. But let me, before we start, introduce, as I was asked, the topic to give some background and to establish a common framework and vocabulary for participants and our audience member on this rather complex issue. So as recognized 10 years ago in 2011 by UN Secretary General in his report on the rule of law and transitional justice, of all existing mechanisms a society has to confront a legacy of mass human rights violations, reparations are arguably the most victim-centered justice mechanism available and the most significant means of making a difference in the lives of victims. Now, when talking as we are about victims of sexual violence, we can assume that we're talking about persons whose lives have been most deeply affected. Long-term consequences of rape and other forms of sexual violence during conflict include trauma, depression, low self-esteem, sexually transmitted diseases, fistulas and vaginal or anal ruptures, incontinence, long-term bleeding, loss of reproductive capacity, unsafe abortions, unwanted pregnancies, and forced motherhood of children for whom survivors might not be able to provide. And if to this multiplicity of harms ensuing from sexual and reproductive violence, if this is already challenging, it becomes only more challenging if we take into account the fact that the experience of sexual violence is typically accompanied by social and symbolic multipliers of harm in the form of stigma, ostracism, and rejection by actual or potential partners and family members. Now, in spite of this, only from the beginning of the 21st century do we find evidence of a growing awareness that it is important to include and understand the specificities of violence against women in general and of sexual violence in particular when addressing reparations, and that reparations must be gender sensitive. Over the last 15 years, the international community, civil society, the United Nations deserve acknowledgement for calling specific attention to the need for reparations and redress of survivors of conflict-related sexual violence. Pioneering this domain was the adoption of the Nairobi Declaration on Women's and Girls' Right to a Remedy and Reparation in 2007 by women's rights activists and survivors, a declaration that many saw as duly supplementing the UN Basic Principles and Guidelines on the Right to a Remedy and Reparations that were adopted just 1 year before. Now, since then, Security Council resolutions, international and regional case law, as well as other soft law instruments, such as the 2014 UN Secretary General Guidance Note on Reparations for CRSV, have continued to underscore the importance of reparations for victims, as well as the need that they include sexual violence and that they be gender sensitive and possibly transformative. So what we have now in theory is an increasingly recognized international responsibility, as well as a chartered territory that spells out certain modalities and typologies of reparations that a country can choose from when addressing its responsibility towards victims and family members for its wrongful actions and omissions. Thus, additional to judicial remedies, both national and, when exhausted, international, many have endorsed the view that in post-conflict scenarios, the combination of weak and insufficient judicial institutions and a large group of victims with multiplicity of harms and needs may make the prospects of judicial reparations slim, and that therefore countries should consider supplementing judicial venues with large-scale administrative reparation schemes, which can simplify procedures, they can lower the thresholds of evidence and spare victims the trauma of cross-examination and secondary victimization, especially in criminal judicial procedures. Indeed, a growing number of countries are opting for this option, which also allows them to simplify redress mechanisms by playing with a combination of benefits, some of material, some of symbolic nature, some targeting survivors individually, some collectively, rather than attempting to provide each and every affected victim with all the modalities of reparations to which they are entitled, which can include measures of restitution, compensation, satisfaction, rehabilitation, as well as guarantees of non-repetition. So official apologies, commemorative events, pensions, educational opportunities, access to health services, individual payments, and collective reconstruction projects are just some of the most commonly envisaged reparations measures in a growing number of countries which have adopted reparation schemes. Now, these reparations programs, unfortunately, remain to this day hugely under-implemented, and I suspect that this under-implementation for lack of capacity or will and what can be done about it will be at the center of our dialogue today. With that, I would like to start by giving the floor to our first panelist, Professor Clara Sandoval Villalba. Clara is a professor at the School of Law at the University of Essex, and is a qualified lawyer. Her primary area of research and work has been on transitional justice and especially on reparations issues. And she was one of the lead drafters of the UN Secretary General Guidance Notes on reparations for conflict-related sexual violence. She has worked on and researched extensively on both domestic and international reparations processes. Clara, it is a pleasure having you with us today. You have really worked and studied different domestic reparations programs in many countries, Colombia, Guatemala, Peru, and Nepal. And you have specifically focused in your studies on reparations for sexual violence. So I would like to ask you, in your experience, what do survivors most want and need from reparations programs?
Hello, everyone. It is a great pleasure and honor to be part of this panel today and to be able to address with you and discuss with you some very key issues that are at the heart of reparations and enabling reparations for victims of sexual violence. I really want to thank the team of experts for the invitation and for giving me the floor and the opportunity to share some of my experience and reflections on reparations for victims of conflict-related sexual violence. On your question, Ruth, I would like to say that they expressed often different needs and different wants, but there are some issues that are always present, and I want to refer to them. The first of them is rehabilitation. Victims of sexual violence, as you were indicating, suffer a variety of harms, including physical and mental harms, and of course, the destruction of their life plan. They lose their families, they lose their children, they lose, in many occasions, the possibility even to conceive kids. All of these harms need to be addressed through reparation programs. And in my experience studying these programs and working with victims of sexual violence, they definitely need, as a habilitating element, rehabilitation. This is a primary form of redress because it becomes the factor that would enable the victim to enter the process of recovery and to be able to exercise rights. If we say that behind the discussions on transitional justice, one of the goals is recovering the idea that individuals have rights and that they can be right holders and that they can exercise rights, then rehabilitation fits into that equation by saying to us, without rehabilitation, victims will not be able to be in that position to even seek justice because they are dealing with the permanent harm, not only physical and mental, but all the others that ensue as a result of sexual violence. So rehabilitation is absolutely of the essence. And I also want to note something, and is that during the process of rehabilitation, something that will hamper rehabilitation is, for example, that it comes late. Most often when domestic reparation programs are set up, they happen 10, 20, 30 years down the line. And in many occasions, these victims have not even had access to any kind of assistance to try to respond during those first hours after sexual violence happens to the harms that could be addressed immediately. For example, contraception. For example, tests in order to see whether sexually transmitted diseases are at stake, etc. So valuable time is lost that should be really addressed through reparations in order to habilitate victims. So that's one key element that I want to mention. But the other element is that if the circumstances, the causes of the violence remain in place, the recovery of the victim is also going to be affected. So you will not gain much by giving, psychological support to victims when you know that the perpetrator that carried out the harm is your neighbor, and nothing is happening to that person, and that person is literally at large, being able to continue that cycle of violence. So rehabilitation is at the heart of habilitating victims of sexual violence. The other key element that always comes up is the idea of recognition. And here I want to put forward that we need a really thick concept of recognition, not one that is just simply the rhetoric of saying, yes, this happened, you are a victim of sexual violence, this should have never happened to you, but really a recognition that is linked to the idea and the international obligation that these acts must be investigated, that those who carried them out need to be brought to account, and that punishment should happen as well. This would send a clearly exemplary message from the law, a symbolic message from the law to societies that all the time naturalize this type of violence. So recognition needs to operate at different levels. This is what sends the message to society that will transform that context of meaning that has naturalized sexual violence. So recognition for victims is absolutely crucial. But again, when we look at the actual implementation of recognition, states, for example, at times recognize responsibility, but they do it in a highly rhetoric manner. Impunity remains pervasive, and I will talk about that in a moment. So while we don't address that issue, I think recognition will continue to be a minimal. And on this point, I also want to say that domestic reparation programs, most of the times, recognize the condition of victimhood, but they don't recognize other dimensions, like the full truth of what happened, etc. And that's why we need other mechanisms in transitional societies to help us recover that full truth about why it happened, when it happened, who are those responsible, what are the conditions that allowed and tolerated that type of practice. And two other factors that I want to mention fairly quickly are we also need, well, adult victims of sexual violence in particular, always note that they require better conditions for them and their children. I've heard this in many occasions, and I have very present in the Central African Republic, victims of sexual violence saying to us, we don't want, this is in the Bemba case, we don't want in this particular case reparations that much for us as for our children, because we don't want our children to tomorrow become the perpetrators. So we really need to provide them with a future. We need to give them education, and education was always stressed as something that is definitely needed. And another key point that comes up a lot is they claim lost opportunities. Of course, by the act of sexual violence immediately means that victims lose access to the financial support they had, to their partners, to their families, to work, to education opportunities, because of the ostracism and the stigma and all the multipliers of harm, Ruth, that you were referring earlier. So I just mentioned these ones, but I think these are crucial.
Thank you, Clara. Now, drawing from your experience, what can you identify as the major challenges at national level when it comes to implementing reparations, both programs, but also judgments? What would you say are some of the major challenges?
Well, there are various ones, some that are specifically related to sexual violence, and others that would apply across the board to all victims of the armed conflict. So in relation to sexual violence, I identified particularly lack of safe places and safe procedures to allow victims to come forward. That's a major gap in domestic reparation programs. And I think that the team of experts could definitely provide great support on how, for example, the justice system should work in a way that is gender sensitive, but also creates procedures that are not re-victimizing, etc., and that give the victims that feeling of confidentiality and trust that they need to be able to speak out on these issues. The other key dimension is the security conditions that I said are not only related to the armed conflict that in many occasions continues, but also to the fact that the perpetrators are at large, that they live with the perpetrators in their communities. So there are no safety conditions for victims to come forward. And of course, there is the whole issue about lack of relevant data and under registration, precisely because of a stigma, silence, re-victimization, lack of adequate access to timely health services, and the like. So these three factors make very difficult to design the most adequate domestic reparation programs and to implement them when you actually implement them. But there are other dimensions that I think we need to bear in mind. The first one is impunity, and I was referring to it in relation to the comments I made in relation to your first question. When impunity remains rampant, you are not addressing the structural causes of the violation. States and the international organizations like the UN and donors are missing a massive opportunity to really send a message, an exemplary message to society that this should not happen again. So I was, for example, this week dealing with a case in relation to Colombia, and just to to put this, and I put Colombia here because it's one of the countries where lots of measures have been taken to provide reparation to victims of sexual violence. But you would be surprised, or you might not, to hear that, for example, the Colombian Constitutional Court sent to the prosecutor's office about 627 cases of sexual violence to be investigated since the year 2008, and some others in the year 2015. After all of this time, there are only decisions in 16 cases. That means that the impunity level, and these are the ones that get there, is about 98%. Yes, so these victims are in the country trying to seek justice, but the system is not responding to them. So implementing reparations, because it's not only necessary to have these beautiful laws, but you also need to be able to support the implementation financially and in terms of technical ability and capacity during the 20, 30, 40 years that this will last. If you look, for example, at Chile, it's not a conflict situation, but for example, they have been implementing the price system on health for over 3 decades. Yes, and this will continue. So you need to ensure that the political support is there, that society agrees, is absolutely on board with the need to recognize this right and to implementing that right. And just I will finish with this final comment because I know I am arriving to the end of my time for this. And is a major problem is also that there is this bureaucratic violence in the system and these gender stereotypes at work that again victimize victims of sexual violence. And I think we need to do a lot of work with that because that, again, puts off the possibility for victims to really use the system. So re-victimization is constantly in place. So I think I will leave my comment there, Ruth, for the moment.
Thank you, Clara. I'm sure we'll come back to some of these many issues that you have discussed. I want to now turn to our next panelist, who is also familiar both with the implementation of reparations programs globally and at the domestic level. Mr. Igor Sepkovsky is a senior advisor on reparations to the new Global Survivors Fund, a new initiative in the field of reparations started by Nobel Peace Prize winner Ms. Nadia Murad and Dr. Denis Mukwege. But previously, Igor also worked with the International Organization of Migration's Land, Property and Reparations Division on the delivery of reparations globally, including for survivors of conflict-related sexual violence. Igor, it's wonderful to have you here. And I have 2 questions for you. And the first one relates to your previous work at IOM. What would you say were some of the biggest challenges for delivering reparations at the domestic level in conflict or fragile settings, where we've heard the needs are often great and across multiple sectors?
Okay. Well, hello, everyone. And thank you very much to the team of experts and also to their partners for inviting me for this event. I have been following the dialogues for quite some time, and I have been learning a lot. And I'm also very happy that we finally reached the point where we are going to discuss my favorite topic, and which is the issue of reparations. Thank you very much also, Ruth, for the skillful moderation and for the good introduction, as well as the very interesting question that you posed. And I'm also happy that I can wear both hats today and also call upon from some of my experience from before. I mean, you asked the question about what are the challenges and difficulties in terms of either starting or implementing reparations for conflict-related sexual violence, or reparations in general, in situations and in countries where it is not so easy to do so, particularly in a post-conflict situations. And in a way, I'm also happy that you said that there is an increased take-up by the government in terms of coming up with reparation mechanisms on the ground, and there are a couple of good examples. And I'm also happy that Clara also mentioned that already some of the challenges, such as lack of political will and lack of resources. So I'm going to expand a little bit on those challenges, and clearly they can be divided in 3 categories. And Clara already alluded to those. I mean, these are typically the lack of political will. In many situations, the countries or the states which are responsible, primarily responsible for designing and implementing administrative reparations program, they don't want to acknowledge that the sexual violence is something that happened in their history or on their territory and so and so. And this is for a variety of reasons. Some of the reasons are political reasons, because they don't want to present themselves, it's the case of government, as a perpetrator, so therefore they don't want to acknowledge. Sometimes these political reasons are linked to the current political environment, where they don't feel that they have enough power to push the agenda of transitional justice and reparations forward, and so and so. So typically, acknowledging it's an issue for many of the governments, and you can look historically in a couple of countries. For example, if you take Nepal as a case, the issue of sexual violence was never acknowledged over there, and the victim of sexual violence were not included in what was called interim relief program for the victim of sexual violence over there, and that would be for a variety of reasons. Other countries, they have different kinds of problems, and sometimes this type of problem that I'm going to talk about briefly, they're not unsurmountable. These are typically the technical or of lack of knowledge about what reparation is and how to organize the process of reparations. And these are one of the problems which are probably less difficult to solve. Obviously, there is a lot of experience among different countries in the global south as well as in the global north about how to organize and implement reparation process. And there is also in some cases national experience how to do so. So the know-how in terms of reparations or compensation, it's not difficult to find, and that's not a challenge that cannot be overcome in some way. However, very frequently also states, when they design reparation programs for human rights violations or sexual violence in particular, they tend to typically think of very simple, not necessarily comprehensive approaches. And in many cases where there is a compensation culture in the country already existing, they typically think of the reparations as simple compensation. So typically this requires also, in many cases, engagement and particularly sharing experience from different countries. So the states and the policymakers who are in charge of opening the views and starting a discussion about policy and implementation of mechanisms, they understand the reparations in a more comprehensive way. And as Clara said, it is very important for victims of sexual violence, particularly when it comes to reparations, that there is a comprehensive approach, that there is an acknowledgement component, there is a satisfaction component, and more particularly rehabilitation component, which is extremely important for survivors of sexual violence. And finally, one of the biggest challenges is which states arising from coming out from conflict typically face is the many priorities that they have to juggle, and in this, and this certainly impacts, their capacity to allocate adequate resources. And there are different ways and different pathways that the states have taken in this regard, principally through from the regular government budget. Frequently by additional taxation, but there are also other innovative models, which I believe my co-panelist Yasmin will be able to talk a little bit more in detail later on. So I will stop here and go for the second question.
Yes, Igor, I do have a second question for you, trying to draw on your current experience at the Global Survivors Fund, which some of our listeners may not be familiar with. Now, I understand that the Global Survivors Fund, one of the things it tries to seek is to provide some provisional or interim reparations that we've heard are so much in need. At the same time, one does wonder, how does the Global Survivors Fund reconcile delivering in this area while at the same time maintaining loyal to the idea and the notion that reparations are really a duty under international law that falls on the state or non-state actor for committing an internationally wrongful act? How can the two be reconciled? Can you tell us a little bit?
Thank you very much. In a way, the two questions are related, and both yourself as well as Clara, and myself, we already indicated that there is obviously a challenge out there in terms of not only designing reparation programs, but implementing reparation programs, and that the states who are responsible for designing and implementing those reparations programs are falling behind. So obviously, we are not in a situation where we are able to say that the things are going well, that there are reparation programs. Notably, some countries have made some progress. If you look at, of course, at Colombia, if you look at Iraq at the moment, as of recently, they have adopted a law on reparations. If you look at Kosovo, in Croatia, and a couple of other places, you will see some progress. But most of the other states, they fall behind. So the idea about the Global Survivors Fund came because of this identified gap in terms of lack of willingness, lack of capacities, or lack of resources in some country to move forward and implement reparations programs. And also, in the same time, the realization that what the victims want, but they get least, want most, but they get least, as Madame Pantin has said once, is that is reparation. So coming from this realization that there is a gap out there, and coming also from the realization that there is a demand on behalf of the survivors for reparations, this is what gave impetus to the creation of the Global Survivors Fund. And of course, having Dr. Mukwege as someone who has worked on this particular issue for quite some time, and having Nadia Murad as a survivor herself, that had an impact. Now, of course, we in the Global Survivors Fund, there is a clear realization that the primary responsibility for implementing reparations resides with the states. And there's no question about that. It's either with the states or it's with the perpetrators when there's a judicial process. So we in the Global Survivors Fund, we basically don't see any conflicting approaches, in terms of what we are doing as an interim reparative measures, and what is general notion about who is responsible and who should provide reparations. So we start from the position that the states are the ones who are responsible. So there's no question about that. But we also realize that in many cases, the survivors, they don't have an access to reparations, and the states, they're not either willing or capable to move forward. So it's a lacuna which exists internationally and at the national level, etc. Hence the idea about establishing a fund which will act upon three pillars. And these three pillars are act or provide interim reparative measures in cases where there is a dire need and the state is not willing. The second pillar of the work of the fund is advocate with the states to develop and implement reparation programs, to accept their responsibility and move forward. And the third pillar is guide, which is to provide technical assistance and guidance both to civil society and to states how to move forward. So if you look from this perspective, you will see that these three approaches are complementary. So even if the Global Survivors Fund goes out and implements interim reparative measures program in some country, that is definitely accompanied by advocacy effort and trying to guide the country toward developing and implementing their own reparative measures, the state's administrative reparative programs. So this is in a way an approach which also acts in a catalytic way, because when we engage in the country, as I said, with interim reparative measures, which provides different type of assistance and care to the survivors, we also engage in the same time with the country in terms of advocating with the particular country how to move forward and how to engage particularly the survivors in design and implementation of the reparations programs. So that sort of enable us to move forward simultaneously with providing interim reparative measures, but in the same time doing advocacy and also providing technical assistance to everyone who is responsible to work on this.
Thank you, Igor, for this brief overview of the fund and explaining to us its operational philosophy and methodology. We will certainly be looking forward to how the Global Survivors Fund impacts the reparations agenda for survivors of conflict-related sexual violence more generally and across the globe. Our next panelist is Ms. Aude Le Goff, who is a program manager at the International Criminal Court's Trust Fund for Victims. Now, the Trust Fund addresses the harm resulting from crimes within the jurisdiction of the court and ensures the rights of victims and their families that they are upheld by providing them with both assistance and reparations. The ICC Trust Fund has two distinct mandates: to provide assistance to victims of crime within the jurisdiction of the court and to provide reparations in the case of guilty verdicts. Can you maybe explain to the audience how the fund implements both mandates concurrently?
Thank you very much, Ruth, and good afternoon to everybody. So indeed, the Trust Fund have a reparative mandate next to the ICC. When we talk about the Trust Fund, it's very much about complementarity with the court, but complementarity between the two mandates too. The first mandate is a mandate of reparation, so it intervenes at the end of a case. So when someone is convicted by the ICC, the Trust Fund mandate is activated and we can implement the reparation order if decided by the judges. Of course, it very much depends of the charges, because if the charges don't incorporate conflict-related sexual violence, so we could not deliver reparation for the victim of sexual violence. For example, currently I'm working on the Almadi case. We have been convicted for the destruction of the cultural heritage in Tombouctou. The crimes of war is only related to that and does not include all the other crimes, including sexual violence that have been committed during the occupation of Tombouctou. As a result, we are not able to implement reparation, judiciary reparation for the victim of sexual violence in relation with this case. If we take the Lubanga case in DRC, who have been convicted for the use of child soldiers, the situation has been very difficult because within the victim, you had children who have been suffering from gender-based violence, sexual gender-based violence. However, because Thomas Lubanga was not charged with this kind of crimes, the harm of the victim related to the sexual violence could not be addressed by the reparation. And you had a decision from the appeal chamber saying very clearly that Thomas Lubanga could not be liable for that. So this was a terrible decision for the victim. However, I think that we are all learning, and if you look at the charges that has been set up by the prosecutor against Ongwen in Uganda, or against Ntaganda in DRC, or Alassane in Mali, you have a number of charges related to conflict-related sexual violence, meaning that for the one already convicted, we will have reparation to address this kind of harm. And for Alassane, I mean, the trial is still ongoing, so we will see based on his culpability if one day we can address this. So it's very important when you are the prosecutor to take into consideration the reparation at the stage of the investigation and prosecution. Then you have the second mandate, the mandate of assistance. And it's not one or the other. You could have both mandates in one country. For example, here in Mali, you will have the reparation mandate, and we are currently launching the assistance mandate. The assistance mandate, the principle is that maybe we don't know who are the perpetrators, maybe we don't have a trial, maybe someone is not convicted, but the victim still has the right to benefit from reparation. And the assistance mandate allows the trust fund to open some program in order to address the harm of the victim of the situation, so not related to one perpetrators. The design of our program very much depends of what is done in the country by the state, because we are not here to replace the state, we are here to complement the efforts of the state. So when I was working in DRC 10 years ago, we didn't have a national program of reparation in DRC, meaning that the gap was everywhere, and it was very difficult to design a program in complementarity with the state because you didn't have a response. Where I'm working now in Mali and in Côte d'Ivoire, in both countries, you have or a national program of reparation, or you have a program of reparation being designed. So in CIV in Côte d'Ivoire, you have a national program of reparations that is being implemented. However, the national program did not specifically design a reparation, administrative reparation for the victim of sexual violence, meaning that they could access to the reparation program, being part of the category of victims suffering for physical and psychological harm, but they don't have a specific arrangement to access to reparation and get the harm specifically addressed. In Mali, you have a program, a national program of reparation being currently designed. The conflict-related sexual violence have been taken into consideration and are part of the national policy currently being discussed at the national level. So for us, for the Trust Fund, we are assessing the gap when designing our program and seeing where could we intervene. And for example, here in Mali, so you have the government setting up a national program of reparation, but it will not be active between 1 year or 2 years. So we have this period of time in order to deliver assistance to victims, including conflict-related victims, waiting for the government to be ready to deliver reparation. Then we will reassess, should we continue with the assistance program or should we end up on the, and we hope to hand over to the government. I hope I am within the time.
Yes, yes, thank you. Maybe just a quick follow-up, Aude, since you have an extensive experience in DRC, can you maybe exemplify more in detail how the assistance program worked there in terms of survivors of conflict-related sexual violence? What were the major challenges, but also maybe some achievements that you could point out?
Thank you. So I think the main challenge, and I may join Igor and Clara in identifying, the challenges, because we are all facing the same challenging. I would say that first is a question of capacity, and even if we are more and more practitioners working in the area of reparation, we need to work with organizations able to deliver services, and usually they are humanitarian or development actors, and they may not know what reparation means and why they should be developed in another way of humanitarian and development assistance. So we have a huge role in supporting the implementing partner, in understanding what reparation means and how to implement that. And I think it's one of our big responsibilities in building up these capacities. The second is the access to the victims and the security. For example, currently I work in Tombouctou. Going to Tombouctou these days is very difficult. It's a lot of procedure to access there, but even when we access, you have all the issue of security. And of course, not only for us, but for the victim we are dealing with, and ensuring that when delivering or when contacting the victim, they will not be in danger. Availability of services is another big challenge, because victims are in huge need of psychological support, for example. And in a number of countries, you could not find these services, or you could find them, but maybe not of excellent quality or not in enough quantity. So this is another big challenge. I would like to stress two other challenges. First, it would be the importance to include the community when you deal with victims, especially victims of conflict-related sexual violence. So one example would be in Congo, we had a project of assistance for the female child soldier coming outside of the harm group with some babies. And of course, they were rejected by the family. It was very difficult for the family to deal, with this baby and with the girls coming back. So when we were dealing with these girls and trying, to address their needs, for the family, it was like a relief, because we were taking care of the girls. Because we were taking care of them, the value of the girl increased in the community, but still for the community, they didn't want to accept what happened. And for the girls, they were kept in an absence of dialogue with the family and the community, and so always doubting about what they have suffered. because of this taboo in the community. And it's very important to be able to work, and especially with psychologists, to work and to understand what the community is going through, why the community behave like this, because I think it's very difficult for the community to, because at some points it means recognizing that they were not able to protect their children when it was the responsibility of the parents and the community to protect the children. And for them, it's a huge trauma too. And so if you focus your reparation only on the girls and you don't take into consideration the trauma and the culpability of the parents and the family, it will be very difficult to address and to recognize the harm of the victim. So this was one of an example. Another one, it's the importance to focus on the victim and to be ready to change your program. Of course, you know, we write project, we try to get some fundings. It's very difficult to get fundings for the reparation. And when you have to change your program because the needs or the harms of the victim change, it may be a bit tricky. But let me give you an example. So still with this female girl coming outside of the harm group, they had a baby. It was already very difficult going back to school. We set up with implementing partner a daycare in order for these girls to go back to school and to have someone taking care of the baby. And when they were in this program, many of them get pregnant again. And so the first conclusion of the team was, okay, there is a lack of protection. These girls are not able to protect themselves. And so I remember we wrote some TORs, you know, to work with some specialists to say, okay, how can we work on strengthening the self-protection of these girls. And in fact, when we work again with a psychologist, you know, and we took some time to look at the mechanism, to talk with the girl, to understand what they were going on. It was not that they were not self-protecting themselves, because it was they were willing to get their baby, and it was like they were owning again their body and their sexuality and the relation with guys, and it was baby of love and not baby of a forced rape. Of a rape. And of course it means a lot, because of course they will not be able to continue school, or it will be much more difficult, and the reintegration and the rehabilitation program will be much longer or maybe different. But it's very important to be focused on the victim, and if it was their choice to get another baby, okay, we may have to adapt the program and find another way to accompany them. But what is the most important is the way the victim choose to address her harm. Thank you.
Thank you, Aude. I think this is a wonderful example that you shared with us. Often we get entangled in our notion of transformative reparations and what that should be, and then you're confronted with realities that tell you what survivors prioritize in terms of their own conception of reparations. And I agree with you that should be very carefully listened to. Now, our next panelist is Ms. Yasmin Walji, and she is a human rights lawyer and the international pro bono partner for the global law firm Hogan Lovells, which is one of the largest law firms in the world. Yasmin herself has been a consistent advocate for compensation for victims of crime, including acts of terrorism, and by those terrorist groups that commit conflict-related sexual violence. Hogan Lovells further delivers 200,000 hours of free legal advice through its pro bono program per year, which is quite impressive. Yasmin, it's a pleasure to have you here. You are an international pro bono partner at this firm, which gives us a private sector viewpoint. Hogan Lovells has been focused, among other things, on seeking ways to secure the payment of reparations to victims of conflict-related sexual violence. And in the last years, you have legally represented victims of ISIS who are pursuing the payment of reparations by Australia before a court in South Wales. So I wonder whether you can tell us briefly about that case maybe, but also about how these pro bono efforts fit in your larger advocacy efforts to secure that funds confiscated from terrorists, including through international sanctions, revert and are used in favor of their victims.
Thank you, Ruth. I'm delighted to be here. It's an incredibly important discussion, and thank you to the team of experts for inviting me. very happy to discuss the case and how it's led to our wider thought processes about how we can finance reparations. We've been representing 5 Yazidi women for free, as you say, on a pro bono basis. They were survivors of enslavement, sexual violence, crimes against humanity, and also obviously terrorism, perpetrated by an Australian foreign fighter of so-called Islamic State. We made an application under domestic law in Australia for a victims assistance payment, which entitles victims of an offence to a recognition payment, which is limited. It's about 10,000 Australian dollars. And we chose this route because, like many Yazidi women who've experienced such atrocities, despite cooperating with law enforcement in Australia, a prosecution wasn't possible. They could identify the perpetrator, but the Australian Federal Police were unable to locate him. And in fact, he may well be dead. Secondly, at the time, there was no alternative national or international opportunity to seek redress or any form of recognition of the harm perpetrated by this group of foreign fighters. We exhausted all avenues. We obviously went to the ICC, the German war crimes prosecutor, the Australian war crimes prosecutor. Obviously, there's a slightly new situation which has developed in Iraq recently, but there really was no alternative. And at the moment, as we've heard, whether it's the ICC's Victims Trust or the Global Survivors Fund, these are largely funded by voluntary payments by some nations. And it seems to us that there were thousands of foreign fighters from different countries involved in Islamic State, and therefore some accountability attributes to them. Sadly, after 4 years of pursuing the case through the Australian courts, we were rejected just this week, and we were told the clients were ineligible to apply under the scheme. And the courts actually ordered the survivors to pay the costs of the Australian government. And you need to remember this is against a background that the offence committed by the Australian offender was a universal jurisdiction crime. It is an offence which is criminalised in Australia, so actually should have been within the domestic compensation scheme. The compensation and reparations that are available to survivors of victims of terrorism outside Australia, but only some victims and some survivors. So we have a situation where, despite the fact the offences prompted by the same philosophy, the same motivation, and in some cases the same offenders, survivors will be treated differently. The distinction, of course, is nationality. If you're Australian, you can get victims of terrorism compensation, not if you're not another nationality. And finally, the courts refused to engage with the international law around Australia's responsibility for reparations. We, amongst other international law principles, we relied on Article 16 of the UN Basic Principles, that even in circumstances where an offender cannot pay or will not pay, reparations are due. One of the main arguments, however, that Australia raised was really related to the costs of the scheme, which they said domestically is funded by the proceeds of crime of national offenders. And they said offenders who commit extraterritorial crimes were unlikely to contribute to the scheme, and therefore it shouldn't be available to the Yazidi clients. And that got us thinking about the potential sources of financing. We've heard already how challenging it is to finance reparations, but we think there are 3 ways where there may be an opportunity to finance reparations. And last year, we prepared a report which identified 3 avenues for financing of reparations funds. And I think one of the colleagues from the experts group is going to put it in the notes for us. Last year, we prepared this report, and it looked at 3 different areas: the confiscation of assets frozen by virtue of sanction, and the fines and penalties for breaches of counter-terrorist financing legislation. So let's turn to the first one, and I'll slow down because some of this is a little bit more complex in terms of finance, but it is rationally very logical. Around the world, we can see sanctions designations being used on a regular basis to freeze assets. We've seen this with the Magnitsky sanctions for human rights violations, but also UN Security Council resolutions. For example, on Daesh, there's 2253. But around the world, victims' organizations have no idea how much has been frozen or confiscated. So we got thinking, would it be possible to set up a transparent system which has due process guarantees for the designated individual, but which allows the survivors to request consideration of reparations financed from these frozen assets? At the moment, the system of designation listing for financing is very opaque, both for the designated individual and for the survivor of their potential acts of violence. So we need to know more about the system of designation, and we need it to be more robust and built on stronger evidence. We know, for example, there is a UN ombudsman process which allows the designated person, the potential perpetrator, to apply for the sanctions to be lifted. But the survivors don't get a look into that process. And if we don't have a system, there is a real danger that assets which have been frozen by sanction may be frozen in perpetuity, forever, or they may end up going back to the state or the individual designated person. And what seems strange to us is even the interest on those frozen assets might be usefully made available to a trust fund. States will raise the question of the right to property of the designated individual. But the point is, there must be a process to challenge designation, and surely the right to property must be balanced against the right of the victim of sexual violence to reparations. There is no absolute right to property. And actually, there's some interesting examples which I can come back to, how confiscation of assets occurs in Italy around mafia operations, which is an interesting example. The second avenue is fines and penalties imposed for terrorist financing legislation and sanctions. There is a plethora of terrorist financing legislation out there. And you will know that governments regularly impose sanctions. If they're breached by an institution, a government will institute a fine or a penalty on the institution. The proceeds of these fines and penalties don't go to the victims who suffered as a result of the breach of the sanction, but they go to the government that imposes the sanctions fine. It's probably best if I illustrate this through an example. In 2015, it was a Scottish company, the Weir Group, was fined £3 million for breach of UN sanctions imposed on the regime of Saddam Hussein. Additionally, the UK government, Scotland, confiscated £13.9 million for proceeds of crime. Those funds didn't go to the victims of Saddam Hussein. They went to a community fund for the national government of the UK. And no reference was made to the victims. There was a small discretionary payment, which eventually went to finding the financial basis for the Iraqi Youth Orchestra, but that was really a one-off. So there are precedents out there that we can rely on. And as I said, at the moment, the Global Survivors Fund, the ICCC Fund, it seems that the balance of the financial obligation is falling on some states. But as I said, many states contribute particularly to the Islamic, so-called Islamic State situation. Many of their foreign fighters did so. And so it is really important that we start to explore this sanctions and asset freezing regimes around the world, including. We have come up with 3 calls to action. We think that if we're to take this further, the international community and survivors funds need to better understand what's going on in terms of confiscation and freezing. We need greater transparency imposed on member states as to what they have frozen under sanctions and what they have confiscated. The UK and the United States disclose how much they've frozen. At the moment, we know there's £100,000 of Daesh funds frozen. But Australia, for example, doesn't disclose what it holds. So we need a universal disclosure resolution on all states to disclose what they have frozen. I would also like to propose that the UN Security Council, when instructing states to designate individuals and impose sanctions, they must also empower the states to implement confiscation of the assets, of course, respecting due process guarantees of the individual that's been designated. And that proceeding needs to be transparent to allow victims to make their case. There is one example of a UN sanction in respect of Libya. It was 1970, Article 18. It said the frozen assets must be made available to the benefit of the people. Now, we think it's possible that on a regular basis, UN sanctions could make provision for the power of states to confiscate. And the final area would just be to build a coalition from amongst colleagues that are watching and across this panel to examine the legal basis that states have to finance reparations, not just to provide them, but to finance them. And we're working on a legal opinion at the moment, alongside, as Igor said, the Global Survivors Fund, which we think will be an important contribution to this debate. Thank you.
Thank you so much for your long but very detailed and clarifying answer to the question. I think we now have some time for questions from the audience, and I would like to start with a question that says the following. Many of the individuals I deal with are international criminal justice or human rights practitioners. Now, these practitioners have often set to sequence victims' assistance and reparations, including for sexual violence, until after a criminal investigation is over. Now, in the experience of the panel, do victims need to wait for a criminal investigation to be completed before receiving assistance and reparations? Aude, would you like to maybe address this question?
Sorry, I was reading the question. Can you repeat it? Sorry.
So the question is about the sequencing and whether, in your view, victims need to wait for a criminal investigation to be completed before receiving assistance or reparations, as often, is said by international criminal justice or human rights practitioners. What is your view on this sequencing between reparations and criminal justice?
Thank you. It's a very difficult question, but my position would be that the victim deserve reparation as soon as possible, and they don't have to wait for perpetrators to be found and to be convicted. If you look today at Mali, I mean, we are still in an ongoing conflict. You still have a number of crimes committed on a daily basis, and the strategy is not to arrest and to send the perpetrators to trial, but it's more to find the perpetrators and to kill them, to avoid, that everything, any other crimes are committed. So, I mean, if we need to wait for judiciary justice, the victim may never get some justice. So it's very important when we have the possibility to set up some reparation program as soon as possible. But at the same time, if we keep having impunities, I mean, you may deserve the purpose of the reparation. So it's very important to have reparation, but at the same time to continue the fights against impunity.
Mm-hmm. I thank you, Aude. I know that Yasmin would like to add something to this. Yasmin?
I would, and I would approach it from the domestic law situation. It has struck me that at domestic law, victims' compensation is available without a conviction. I act for many of the victims in the past of terrorism, and my firm is currently acting for those that were involved in the Manchester Arena bombing. We can apply for compensation for our victims of terrorism without securing a conviction. So if it can work at a domestic level, why can't it work at an international level? That would be my observation.
Igor, you want to, let's move on to a different question, because there are several interesting ones. Angela Draganic, she is asking, A difficult question. To what extent children born of wartime rape can be entitled to reparations within the current international legal normative framework, given that children can be considered secondary victims of conflict-related sexual violence? Clara, would you like to answer that question maybe?
Yes, absolutely, Ruth. Children born out of rape are victims. The concept of victim under international law, it's very explicit on who is a victim. Victim is any person or collective who has suffered harm as a result of a human rights violation, and that include family members and others. And we have, for example, already at the ICC, two important precedents, but the most important one is the Taganda case that recognizes children born out of rape and considers that they are not indirect victims. The Taganda case actually says that they are direct victims of the harms. So it's fantastic. And in Bemba, in the expert report we presented to the ICC, we also maintained that all the children that were born in the Central African Republic out of what happened there were also entitled to full reparation because they themselves had been victims of that. So I think we are more and more moving to a moment where full recognition is given to this fact, and we need to maintain it. I mean, it's absolutely clear that they are suffering harm and that they need to be put, at the center of justice measures and reparation measures and truth measures.
Thank you, Clara. A question directly addressed at Igor. Igor, how would the interim reparative measures of the Global Survivors Fund look like in practice? Will they focus on compensation or also on rehabilitation, for example, by partnering or optimizing existing services providers? What would you say, Igor?
Well, that depends exactly on what the survivors deem that is going to be reparative for them. So, I mean, one of the approaches, and I think we all sort of subscribe to this approach, is to have a victim or survivor-centric approach, in terms of determining not only the policy, not only the benefit, but also the process. How do you deliver reparations, So on the Global Survivors Fund, what we have is a sort of a process of co-creation, whereby the survivors themselves, they decide about what kind of measure is the most reparative for them, And this is a process where they engage very actively, and they're the one who determine whether this will be compensation, whether this will be rehabilitation measure, etc. So it's our approach at the Global Survivors Fund. It's based on what survivors want and expect, which also answers partially the question which was asked before. Are children born out of rape eligible? If the survivors they say that they need an assistance in terms of supporting, their particular status, having children born out of wartime rape, that certainly is the case. So whatever you do, going back to the survivors and asking them, what do they think is going to rehabilitate them, repair them, etc., is the best approach, and that's how you determine what is the best way to go and what kind of reparation modalities will be in place. Okay.
Thank you, Igor. I have now a question that is addressed to Clara. And the question is, once a reparation mechanism is established, how can we best engage in survivor-sensitive outreach to beneficiaries, given specifically the shame, the stigma, and the protection concerns surrounding conflict-related sexual violence that you alluded to in your own answer before? What would be some ideas of this survivor-sensitive outreach to navigate these issues?
I think, two things I would believe important to the discussion. This is also a complex question, but the first one is the mapping that must happen before any domestic reparation program is created needs to identify the focus of the violence, the focus of sexual violence, and identified also the networks of actors that could be relevant, such as civil society organizations, religious groups, and others that would be relevant to reach the victims of sexual violence. I think that a key actor in work with victims of sexual violence are precisely those networks of trust, those communities of trust, because they are the ones that will be able to help you to navigate the unknown as a state, because the victims don't trust you. So I think that's a key element, to have outreach, to try to get to to the victims and to then offer through them safe spaces. I think, for example, about Kosovo and the important role that 4 civil society organizations have played to implement the domestic reparation program in relation to victims of sexual violence there. It has been through them that victims are registering. They have provided victims rehabilitation mainly as assistance, but they have been key to that process of engaging the victims through the process. So yeah, for me, that would be a key element.
Thank you, Clara. Anyone on the panel wants to add something to Clara's response? Well, if not, then let me move on to another interesting question. And this one is addressed to Yasmin and Igor. So Yasmin, you mentioned novel ways to fund reparations, and Igor, you are now working with the Global Survivors Fund on new models of funding. Is there a way to use public-private partnerships to enhance the provision of assistance and reparations, whether through social investing or social bonds? Maybe you can address the question and briefly explain social bonds. Yasmin, would you like to start?
I'm not sure I can do the social bonds part, but I can certainly talk about the public-private partnerships. As I said, we run a pro bono practice program, which is available to provide victims assistance and legal representation for free. And I think there are ways of collaborating with international NGOs and public sector bodies to try and secure victims' compensation. There are many ways. We've talked about 3 of the avenues just now, but of course there is always civil litigation. And there are ways of coming together so that we investigate the assets of offenders to see whether or not civil litigation might be an avenue to recovering some form of reparations for victims. Obviously, that has to be a public-private civil society collaboration so that we provide victims with the support they need to take them through the system. There is no doubt that we have worked with the Lotus Flower Foundation, which has been fabulous in terms of supporting women through this very difficult and very complex set of litigation that we've engaged on. I also think there is scope for collaboration around research, and particularly research. Firms like ours have the ability and resources to conduct a substantial amount of research, which might be possible. And finally, my third area would be around legal tech. So in commercial litigation, we use a lot of legal tech and AI to draw out themes from witness statements, and we can begin to see patterns. And that's where we have thousands and thousands of documents that we're trying to bring together to develop a case. So I think there's so many areas of potential to work together, and I would absolutely like to see us collaborate more on this area. I will just add one last thing. I do think that there is a good role for financial investigations agencies as well, to start to think about, of the people whose assets have been confiscated or who are under investigation at the moment, where does the victim fit in to making representations in criminal prosecutions or confiscation orders? So I do think there's a chance there to work with financial investigators.
Thank you so much. There's a question from Elizabeth Alexian, and she asks, well, she first of all thanks us for discussing this critical topic, but she would like the panel to address the issue of sexual exploitation, including survival sex and exploitation by aid workers, which is often a form of CRSV, but more difficult to address because of exercise of agency. She asks, how can we ensure that these forms of structural violence are not ignored in discussions of CRSV, and also work to provide reparations and justice for survivors? Maybe Aude would like to say something about this, or Clara, Igor, someone from the panel?
If not, no one wants to, you want to, Igor? No, just a quick reaction. I've been having this conversation with some people lately. And one thing that for me is crucial is, I think civil society organizations, and here, for example, I think about Oxfam or others that have had to address claims on this, are trying to deal with that. So accountability processes need to be in place so that they can acknowledge what happened and that they can take the measures to deal with that. And there you have a very important question, is some of these organizations are doing already assistance work. And when you think in terms of reparation, some of the measures can be quite similar, right? So one question I have engaged with lately is, how do you distinguish those measures that they usually do as assistance from those measures that they will have to take as reparation, precisely for having engaged in this type of sexual violence? And then the whole issue again goes to the acknowledgement, to the accountability process, to the transparency, and to the measures that you take as an institution to prevent this from happening again, no? So it's again the repetition of all these key principles that we have in TGI societies that should also apply across the board, and which are, you know, the cornerstone of human rights law. You need to prevent, and states should act also. So there is not only the responsibility of Oxfam or others like Oxfam, but there is also the responsibility of the states in relation to what is going on with those acting under their jurisdiction, right? So I think it puts on the table very important questions and very pertinent to this issue.
Thank you, Clara. Igor, you wanted to add something to this?
Just very briefly, I mean, this has been a sore point for the international aid system and the UN system for quite some time, and I think that there is not yet a positive and satisfactory outcome on this, because none of the agencies nor the United Nations as a system has accepted the responsibility to provide reparations when any type of crimes have been committed by the aid agency or by the UN system. You know, so I think this remains a problem. So far, the approach has been that the victim of sexual abuse or any other types of violation can address this through the courts at the country from where the individual comes from. And you can imagine that this is extremely difficult for everyone. So I think the UN has to step up its act here and come up with a mechanism which will provide adequate judicial and non-judicial remedies to the survivors.
Thank you. Thank you for your bold answer and taking a position on this. Yasmin, this question is for you, and it is someone who shares with us that in Central African Republic, legal aid clinics were funded by international organizations, both in Muslims and Christian communities, which supported survivors to launch, in addition to psychosocial support, both CSRV and SGBV cases, in addition to working with a psychologist, working with the survivors and training law enforcement and justice partners. So the question is, if FREE's assets could be used to fund legal aid clinics, as well as working on collective prosecution for more victims.
I think the answer is yes. But the problem is obviously trying to secure those assets for reparations funds. And I go back to the three questions that I put, or the three calls to action I made initially. We need transparency from governments as to what they hold and what they've confiscated. We need the UN to empower states to confiscate assets, and we need to build collaborative examples together. So absolutely, once the assets are secured, there is no reason why they shouldn't be. And in fact, they should be used for legal representation of victims and reparations. But the first stage is getting hold of the assets.
I agree, Yasmin. There's one maybe last question I would like to take on board, and maybe ask several of you to share your views on this. So we discussed that community, it must be considered when awarding reparations. But we know that in many large-scale reparations programs, the local culture context is not duly considered. Now, do you think more importance and consideration should be given to local approaches? And if so, how do we ensure this does not reinforce structural discriminatory practices that women tend to suffer pre-conflict? So the importance of attaching significance to local approaches while at the same time not trying to reinforce structural discrimination patterns. Maybe Aude, would you like to start, and then I'll invite the other participants if they want to add something.
I think reparation is a very long process. We could not expect victims to be repaired or to be rehabilitated in a few months or even few years. I mean, it's a question of generation. If you see your whole villages being killed, or your mother, your sister being raped, it's not in some months that you will be able to deal with that and be redressed. So, of course, we need to work with the community, and it's not a question of maintaining the same structure or the same mentality or the same pattern within the community, but it's a question to building the confidence with the community and with the victim, and step by step to work and to change the behavior and to address the reason why the victim were victimized. But if you don't build first this confidence, this relation, you will not be able to work with the victim and the community. So it's a matter of getting into the community, reaching out the victim, and then slowly you can work and work on the transformation of the conflict. I think Igor wants to talk.
Thank you, Aude. Igor, you want to jump in on this?
Yeah, I mean, again, back to the basic approach. If you start, from the survivors and engage with the survivors, you will know actually what's appropriate for the community. I mean, survivors, they come from the community and they live in the community. So if you ask the survivors what reparations means to them and for their community as well, you will get probably the most appropriate answer, and therefore you will be able to design the most adequate programs. In the Global Survivors Fund, there is a committee typically involved around every single project, which also not includes survivors, but it also includes the other community members. It's a very inclusive approach, includes everyone around, including representatives from the local government and so on. So if you take this multi-stakeholder approach, starting from the survivors and building it broader in a concentric circle, that will probably solve the problem about having a community appropriate approach in terms of reparations. Over.
Thank you so much, Igor. Is there anyone, Clara, I see your hand. Do you want to add a little bit on this?
Yes, what I would like to say is that many victims of sexual violence are ostracized, and by that, they lose access to their community. So one goal of reparation should be to try and restitute their inclusion to those communities, families that they lost, and to society overall. No, the question is, how do we achieve that goal? And I think that's where context matters, and the logic of communities matters. But you run the risk, as you said, Ruth, to reinforce patterns of patriarchies and discrimination that we don't want. So I have very present in a country I had to visit. I was talking to a leader about what are you doing to help the victims of sexual violence, and the answer I got was, we're actually finding new husbands for these women. So you should actually be thankful, because this is what it is. Of course, I was like taken by the comment, like, how can you respond that to me? But if you look at the context, that's what makes sense for them. And then you question yourself. I disagree absolutely with that as a matter of principle. But this tells us a lot about how do you go about implementing change. And some of these changes will happen even after that victim is not in this world anymore. And so we are talking about different tempos. Guarantees of non-repetition don't happen from one day to the next. They have different timings that don't always coincide with the timing the victim of sexual violence needs to recover, and that's very unfortunate. And I just put the issue on the table because I don't have answers. I just want to note how difficult this is. But I also have seen how context and communities in other contexts of reparation are incredibly helpful, and in certain contexts. So in Colombia, for example, where the health system is being incapable of delivering health services to victims, a community approach has been taken, particularly with groups where, that hold, as Igor said, they live together, etc. So you create these communities of harm based on their understanding of how to deal with these harms. And this can have very important healing dimensions too. So you can see the pros and the cons of engaging with community understanding of healing or how to behave with your body, etc. But it creates opportunities. So yeah.
Thank you, Clara. I agree with you that one of the most challenging issues is the question of what it takes to transition from one understanding of just gender, ecosystem or justice to a different one, and who is to bear the costs of that transition, and whether we should necessarily expect survivors to bear not only the costs of violence on their lives, but also the costs of whatever it takes to transition into what we think might be a more gender egalitarian order altogether. So I would like to thank all speakers and participants. I think that their presentations and their answers show that the challenges are really daunting. The needs are manifold. Many of them are very urgent and cannot wait. On the other hand, we see that adequate reparations need time. Odd was addressing, the intergenerational dimension of this, but also the fact that, as Igor was saying, we need to think of this as concentric circles where the forms of intervention need to target the individual. But as all of you were suggesting, also the communal level of family, the neighborhood, the village, and the country. And Clara was pointing to the fact that even, the category of restitution might be useful to think about these broken ties and how, part of the redress needs to take that into account. But of course, without tackling the communal dimension, you cannot reinterpret the meaning of sexual violence in ways that shift the stigma away from survivors onto perpetrators. And yet doing that, reinterpreting, this was not of your fault. You didn't do anything to provoke this onto you. This was a human rights violations that triggers responsibility and should trigger reparations. It is very difficult to convey that while at the same time we're still in a situation of impunity, and we're still witnessing massive scale of sexual violence in ordinary, peaceful, so to speak, times. So this goes to the gender violence continuum. Now, the challenges are daunting and progress exists, but it is limited. I would say on the positive side, if we take into account that sexual violence has always been a weapon of war since time immemorial, and that only what has happened only in the last 15 years, I think we have made big progress. I think we have made huge progress in terms of awareness raising on the importance of reparations for victims and for victims of conflict-related sexual violence in particular. We must credit international organizations, the United Nations, IOM, but also the very, very active civil society, and most tellingly, and I would say increasingly, survivors. I mentioned Nairobi Declaration, but I could also now mention SEMA, a global network of victims and survivors to end wartime sexual violence that has been created recently, bringing together survivors from 21 countries and 6 continents, representing more than 90 years of conflict. I think, the fact that these survivors are organizing, that they're establishing ties through local NGOs and victims associations that act as engines of transformation is to be celebrated. And the fact that they can be vocal about this means that the taboo is starting to be broken. And that is the first step to create an enabling environment. I would also celebrate, I think, the knowledge that has been created, also thanks to academic research, of what procedurally and substantively crafting gender-sensitive reparations requires. The fact that we now know that it requires careful analysis and design to take into account the gender relations and pre-existing power imbalances to ensure fair assessment of the harm done to survivors, the knowledge that it must take into account conditions that would guarantee equitable access, but also that any of this cannot be achieved without, participatory processes that that allow men and women to have their voice really meaningfully heard. And I think all of this that has been achieved, the knowledge, the awareness rising, the breaking the taboos, is absolutely crucial because as Clara was saying, victims, and this speaks to my own experience, victims really prioritize recognition. And without this knowledge and without this awareness, recognition won't be there. But of course, words, articles, books, soft and hard law, or nicely crafted policies and programs and institutions with trained practitioners are not enough if actions do not follow, meaning is not achieved, and recognition fails. And I think this is where, we come to implementations and with the hurdles of countries unwilling or unable to implement. And in view of this, I think today's dialogue shows that the many actors that through sticks or carrots can trigger change. I think, international organizations such as the team of experts, hosting dialogues, but of course, doing wonderful in-country work, ICCC reparations assistance mandate we've heard throughout, new initiatives such as the Global Survivors Fund for victims assistance, but also for catalyzing governmental action. Thank you, Igor, for addressing those, but also the private sector, Hogan Lovell, Yasmin, creative ways in which money from global wrongdoers can be channeled in ways that hopefully will better reach the survivors of the worst forms of wrongdoing. And then academics like myself or Clara, who learn from the ground, who conceptualize, who teach, who train, because we deem education to be one of the most transformative tools in this domain, as well as in many others. And on this note and the relevance of training and education, do please allow me to advertise yet another upcoming joint venture, which may be of interest to some of the people in the audience, involving my own School of Transnational Governance in Florence, Italy, the team of experts, and the UN Office of Drugs and Crimes. I'm referring to an upcoming executive training seminar on gender dimensions and women's rights in terrorism and counterterrorism that will be held between the 2nd and the 4th of June. You can join us at our lovely campus in Florence or participate remotely via hybrid online format with a deadline to register on the 22nd of May. I really hope to see some of you there. And with this, I thank you all, and I turn the micro to Chloe to wrap up the session.
Thanks, Ruth, and thank you very much for ending on this extremely powerful, positive note. I think this is the beauty, as you say, of the work stream that we're on, which is there has been positive change, and I think every time we have those dialogues, we realize how much, in every parts of the world, we have colleagues who are working on those issues and who are moving the needle. So thank you, and thank you to the panelists for quite an incredible discussion. The team of experts hopes that we can continue to partner with you all on delivering on the closing gap on provision of reparations for survivors of conflict-related sexual violence in any conflict where this crime is present. So this session will become available online on YouTube and on the Team of Experts website shortly. And we will be continuing the series of webinar next month. We'll have our 7th edition, and it will address the concept of masculinity, gender bias, and their impact on the judicial response to conflict-related sexual violence. So some of the points that have actually been raised, including today. And more information about this event will be posted shortly. Thank you again to our moderator, our excellent panelists, and to the audience for attending this digital dialogue. We hope you will join us for all of those future sessions, and have a good day.